Hello, everyone. Today we're going to talk about trademarks. But first I want to focus on intellectual property in general. Does everybody know what intellectual property is? People have a good idea? Okay. So intellectual property generally is comprised of three different items. You have patents, trademarks, and copyrights. So there are various types of patents. There are two types of patents. There's a design patent and also a utility patent. So to just show you what a patent is, it's basically an invention. So if you take a look up on the screen, you'll see a Coravin. It's the wine preservation system. So they have a patent for going into the bottle, preserving it without actually opening it. And then Heineken came out with Heineken Blade, which is a beer dispenser. So again, this is a smaller, compact beer dispenser that you can put on a counter and you can use also commercially in a very small space. Another type of intellectual property is copyright. So copyrights generally cover artistic or literary works. So a good friend of mine, Steve Ray, came out with a book last year. He published How to Get U.S. Market Ready, and it's a very good read, by the way. And so when you publish a book, or if you write a screenplay, or I have a piece of art that I drew or painted, you would get a copyright. And normally when you see a copyright, you'll see an encircled C. It'll have the year in which it was produced and the person's name. And then next we have trademarks. So we're going to be concentrating on trademarks today. So a trademark is generally your brand. So if you're producing a wine, a spirit, a beer, and you have a label, generally what you're going to have on there is your brand. So it's going to signify the source, somewhere that product is coming from. So here I have a product called Ballyhoo. This is actually a registered trademark. And as you can see, because it's registered, it has an encircled R next to it. So that designates that it's actually been federally registered and it is used across the US. Now, if you see a designation of a TM or an SM, that generally means it's a trademark or a service mark. But what it's doing, it's actually putting people on notice that that's your trademark. So it may not be federally registered, but you still have rights when you use a TM or an SM. So what is a trademark exactly? Well, what it is, again, it's an identifier of the source of where the products are coming from or their services. So if I'm selling distilled spirits, you want to know that I'm the producer, I'm producing this type of quality, and it distinguishes it from somebody else. So I can have I can have a word, I can have a design, I can have a symbol, a combination, a phrase, a slogan. So that is generally what a trademark is. A service mark, on the other hand, relates to services. So if I'm offering my legal services and I have a trademark, or if I have a slogan or a brand for my services, I could identify that with an SM. Oftentimes people get confused between a trademark and a domain name or their business name. So I've had clients come up to me and say, oh, don't worry, I have the domain name secured. And I'm like, well, that's great, but did you actually file for trademark protection? And they'll say, no, I have the domain name, why do I need that? Well, they're different things. So a trademark, like I said, if you have a company name, say it's ABC Company, and you get a domain name for, you get a website, www.abccompany.com. Well, that's your website. Now your domain would be abccompany.com. That does not make a trademark unless there is a reason for it to be a trademark. So take example, you have 1-800-CONTACTS. People have heard of that company, right? You can apply for contacts online. So there's their website, and then they also trademark 1-800-CONTACTS.com. Now why is that? Because if you look at the description of the services, they're actually providing online retail services for that product. So you know where the source is. That's where you're actually getting the products. But just because you have your website or your domain name doesn't mean that's actually protected. So they actually filed for federal protection at the US Patent and Trademark Office. So now what types of marks are there? Well, there are a few that we usually distinguish by. So first would be your word mark. So if you take a look above, you'll see Coca-Cola and Pepsi, right? They're your basic word marks. So when you file for protection, you're only reserving that mark. You're not doing it for color, or you can do it for color, but you're not using stylized fonts, you don't have a design associated with it, it's just that mark. I usually encourage my clients to file for word marks because I believe that gives you the greatest level of protection. Because if you have a word mark, you can always associate it with the design. You can always associate it with the style of font. You can mix it up. If you go with a special form mark, such as a stylized mark, as you look below, if you see Coke has their script logo, and Pepsi has a specific font. So when you do that, what often happens, and no offense to any of the marketers in the room, marketers like to change things up. So they like to change the fonts, they like to change colors, they like to change designs. And as consumers, we like that too, right? You like to have some things change. It doesn't always have to be the same old, same old. But when you have a trademark application or a registration, if you change it, well, that could actually change your registration. So this registration right now for Coke in the script, if they change it, if they didn't have the word mark, well, then that wouldn't be protected unless they filed again. Now here we get into the design marks. So design marks can be a combination of words and a design, or a design alone. So if you see the first example, we have New Liberty Distillery. So here it has actually a combination of what we already talked about. There are words, there are stylized letters in here, there's a design, but the combination of it is a design mark, right? It's a composite mark because it has various components to it. And on the right, we have a product, we have a design for a product called Conic, and that's a stylized C. So in this instance, I'm showing these marks in color, but if you file for them in black and white, then you can change up the color. So again, that gives you a little more flexibility. So you're not stuck with exactly what you file for. So sometimes people will actually file in color, designated specifically for fonts, because there may be some little tweaky thing with their application that won't normally get past a trademark examiner, but when you have a combination of things, it actually makes it passable and then allowed to register. So how are trademarks protected? There are basically three ways. Like I said, I was talking about federal registration. So if you file an application with the US Patent and Trademark Office, that would be for federal protection. This gives you the broadest protection because now you're able to use your mark nationally. So if you're selling a product or you're starting a business, you may start off in one state, you may grow regionally, start distribution going down the eastern seaboard, and then maybe you want to go nationally. So if you have a federal trademark, this puts everybody on notice, and then you're able to use it exclusively throughout the country. With the state registration, you're going to file with the particular state that you're in. So if I'm in New York, I may file for just a New York state registration. However, realize that then you're limited. It's only limited to that particular state. So that does not prevent somebody from New Jersey or Connecticut using that same trademark because I did not file for federal protection, I only did it within the state. Now, common law is the last type of registration, which isn't actually a registration at all, it's the last type of trademark, because you don't have to file anything. So if I'm using a mark, say I have a retail store and it's called Donna's Widgets, and I sell in Brooklyn, New York. Well, I may just have a limited audience. Maybe I don't advertise on the internet. Maybe I just have flyers that people are passing by so they come into my store. I don't advertise at all. So it's a very narrow focus, but I have a loyal following. Now, I have trademark rights in my retail store because I've actually been out there publicly using this mark. However, if somebody files for that same name in California or in Idaho, then my mark is limited. So my rights are superior only in New York, or it may only be in Brooklyn. So again, when you're looking at your trademark or your business model, it's always good to really think ahead and see how you can expand your mark and protect it. Okay, so when should you file for protection? Oftentimes, I have clients call me and tell me that they've been using a mark and they didn't file for protection, which always causes me to pause because it makes me nervous. I'd rather see people file for protection initially when they come up with an idea. If you have a trademark and you know that you're going to start a vodka business, so you know you're going to develop a brand, at least one, if not more. So it's always best to do a search, see if that name is available. So say I'm coming up with Donna's vodka. This one's not very original, but if it were, let's pretend. So if I have Donna's vodka, I know that I'm going to build a distillery. I'm going to have to come up with some packaging. I'm going to design a label and all the other good stuff that goes along with it. My advertising, my caps, whatever you can think of that goes with selling a vodka product. So if I know I'm going to do that, it generally takes between 9 months to a year to actually get a federal registration. It's a process. But I also have to build out my store. I may have to produce the product. I have to source my bottles, my labels, all of that good stuff. And to do that, I wanted to make sure that I'm doing it in advance. So I can file an intent to use application, and this way, by the time everything comes together, hopefully I'll have my registration. On the flip side, when I get the call from people who tell me, I have a product, I've been selling it, and then I ask them if they file for trademark protection and they say no, then I take a deep breath. I tell them, okay, let's do a search and make sure it's available because it's really important that you actually reserve this mark or this name. So I had one client who actually did that, and they were very fortunate because the brand name that they had was unique. It wasn't something that everybody else had. So when we looked, the search was clear. We filed for their trademark application, and they were actually able to get registered. They were lucky. Let's think of what could have happened if that were not the case. They already had the bottles out in production, in distribution. They had point-of-sale materials. They had advertisements. They had outer case packaging for the product to be shipped. They had labels, they had point-of-sale material, they had t-shirts, glasses, barware. So when you think of all those things that are branded with that particular name, if it was a mark that infringed on somebody else's, the worst case being a registered trademark, that money is going away. So again, it's really best to do it up front if you can. So there are 3 bases for which you can file a trademark at the federal level. So the one we're talking about, I may have a client that already has been using that mark in commerce. I may have a client now that is looking to start a distillery, so they have an intent to actually use a mark. And then also, if you have a foreign registration or application, that could be a basis for filing your application in the US. So what are the benefits of filing? Well, again, federal registration gives you the greatest protection across the country. So you start here nationally, and then again, you may be able to register in a foreign country. It puts everybody on notice. This is the reason why you get trademark protection. You're putting people on notice that you own that mark, that you have the exclusive rights to it. You have your federal registration symbol, the encircled R, which generally, once you get your trademark, you'll have that around, whether it's a word mark, design mark, or a combination. You have the ability to sue. So if somebody has a mark that's infringing on yours, you can actually sue them. And a good benefit that many people overlook is that there are a lot of gray market goods or counterfeit goods that may come into the US. So if you have a federal registration, you can actually take your registration certificate, go to US Customs and Border, and let them know this is your mark. So this way, if there are any infringing, counterfeit, or gray market goods coming in, then they know that those are counterfeit and that they won't let them into the country. And again, I mentioned that you could also use it as a basis for foreign registration. Choosing a mark. Now, I know people think that they're very creative, and many people are. However, when it comes to coming up with brand names, they always say there are very few new ideas. So for instance, I was looking at the US Patent Trademark database, and I just looked up distilled spirits as a class. And when I looked at how many applications there were, I think there were approximately 50,000. So I'm like, wow, that's a lot. Now, about half of them are active and live. So now if you think about it, if you have about 25,000 applications, and say you take a category like, again, vodka. I'm guessing at the numbers, I don't recall exactly. There may have been 17,000 applications that were live for vodka. Well, if you're coming up with a new vodka brand, how original are you going to be with your new name, your brand? Think about it. How many other SKUs do you have to compete with to get attention, to get a consumer to be drawn in to actually purchase your product? So I think it's really in your best interest to look for a mark that's strong. So there are 5 categories in which you're going to look at your trademarks. They start from fanciful, they go arbitrary, suggestive, descriptive, and generic. So we're looking the strongest to the weakest. Fanciful marks are the strongest ones. These are terms or brands that have been made up. They have no definition in the dictionary. They're just, you could be sitting around hanging out with a bunch of friends and you come up with some funny little word and you're like, that's great, that's a brand. There's no meaning for it. And usually that's the best opportunity that you can have to get through the trademark application process. So example, here you go, Haagen Dazs. That's a made-up term. I don't know if anybody remembers when Haagen Dazs first came out, people thought, like, is it Danish? It must be a foreign product. It's not. Rolex. Again, everyone, loves a Rolex watch. Made-up term. Exxon. Oil producer, another made-up term. So when you hear these names, you instantly understand what that brand is, right? You know the source, you know where it comes from, you can understand the quality. Arbitrary. All right, so that's the next level. Again, another strong mark. Now these are marks that have a meaning. They are defined terms. However, they're used in a different context when applied to different goods and services. So for instance, Apple. We're all familiar with the Apple logo and the Apple name, right? So Apple, obviously a defined term, it's a fruit. But when you apply it to a computer or an iPhone or a TV, well now it's out of context, right? So even though you're using a term that's very well known, when you apply it to these type of products, it's different and therefore it was able to be registered. Camel cigarettes. Here you have a camel, which is an animal, defined term, and it's applied to cigarettes. So again, the context is completely different from what you would think of when you think of a camel, but it works. And then lastly, you got your cute little penguin. So we have a penguin, but now it's related to book publishing. So again, these are types of marks, even though they're basic terms, when you use them out of context, they can be a strong trademark. Now, suggestive marks are the last of the strong mark category. So they actually suggest, but they don't describe what the product is or the service is. So what it does, it requires a consumer to actually think about it a little bit, and they'll be like, oh, okay, yeah, I get it. Not that you have to sit there and really, mull over what it really is, but here's some examples. So 7-Eleven, I'm sure most people are familiar with the convenience store brand. Now 7-Eleven, the terms or the brand came out being because the store was open from 7 a.m. to 11 p.m. So suggestive, right? It's giving you the hours of the convenience store, but they're not saying we're a convenience store. Take a look at whiteout. I'm not sure that anybody really uses whiteout anymore, but back in the day when people actually used typewriters and wrote things down in pen or pencil, there's this product. It was a liquid product that's white, and if you made an error, you would actually swipe the page, dot it, whatever you will, to get rid of the mistake. So whiteout. It's white in color. It suggests that you're erasing something, so suggestive, but not really descriptive. And then last, Jaguar. Jaguar is a very fast animal. So when you apply it to cars, well, the suggestion is that you have a fast car. So again, these are things that, while you think about it, but it's not absolutely clear what it is. So now we're getting into the weak categories, descriptive marks. So descriptive marks actually describe, it could be a feature, it can be an ingredient, it could be a function, some characteristic or quality of the actual product. So no imagination is needed. You look at it, you instantly know what that product is. So it doesn't identify a source. Again, right? Trademarks, you're trying to identify a source. Where is this product coming from? Am I drinking a cola, or am I drinking a Coke, or am I drinking a Pepsi? So there's your, that's how you distinguish between them. These are marks that could be refused registration, but sometimes, depending if there are other qualifiers along with it, you may be able to get around it, but it's usually harder. So if you take a look at some of the examples, I found a mark called red wine. Now the fact that it says red twice doesn't do anything for you. It's still descriptive, right? It's applied to red wine. It's not applied to white wine, it's red wine. So you know what's in the bottle when you're looking at that brand. Next, there's red and black pepper vodka. So what do you think that is? Do you think possibly it's flavored with red and black pepper? So yes, so that's why that would be descriptive. And then last, Jamaican rum punch. Again, you know exactly what's in the bottle, so therefore it's really not distinguishing that particular product from somebody else's. So you want to try and avoid that if at all possible. And then of course the weakest marks are those that are generic. So if you refer to something based upon its given name or the product type or the category, well then it's pretty clear that it's generic. So here, if you have a beer, you're like, I'm going to produce a beer and I'm going to call it beer. Well, that's not novel and you're not going to get that registered. Same thing if you do that with gin, tequila, wine, whatever. So again, it's a good idea, put your thinking cap on. If you're thinking about a brand, try to come up with something a little more unique so this way it actually registers. Now, there's a whole host of other reasons why your trademark won't register. You can file something and it could be somebody's last name, their surname, and the trademark examiner will come back and say, sorry, you can't do that because it's somebody's surname. Now, are there ways to get around it? Yes. If it's a very unique name and maybe there's only 3 in the entire US, it's possible. But again, these are things that you want to avoid so you really don't have to go through the hassle of trying to file for an application, then get into a sparring competition with the trademark office with papers going back and forth trying to refute their claims. So again, you could see the list of additional things. If it's something that's disparaging or offensive, there's things going back and forth about that. If it's somebody's name or likeness, you may have to get an affidavit saying that they approve of you using their name or likeness on a particular bottle or product. So now we're going to go, oh, you know what, also ornamental. Oftentimes people will think that if they put a logo or a name on a hat or a t-shirt, that that's a trademark. It's not. So if you just signify, and I put Donna's Vodka on a hat, well, I'm just advertising my brand. It's not a source from where that hat is coming from. If I were selling hats and t-shirts and sneakers, well, then I'll have a label that says Donna's Sportswear or something like that, and that would be the source identifier for those products. So usually if you're using a mark in commerce, people say, well, we need to see a specimen of what you're doing, how you're using the mark in commerce. And if you try and file something like that for, say, beer, and you give them a picture of a hat with your logo on it, they're going to bounce it back because that won't be accepted. All right, policing marks. If you get your trademark registered, it's very important to police your marks. And what do I mean by that? Okay, there's a bit of a lag there, sorry. So you want to police them because you don't want to dilute the value of your mark. Right? You've gone through this process, you applied for it, you waited the time period, you get it registered, now you have it, now you want to protect it. So I'm sure people have heard of cease and desist letters. This is if I'm a trademark owner, I have a valuable trademark, and then I find out that someone else is using the same mark that I have, or one that's very similar. It could be the same name, it could be partial part of the name, it could be part of the design, and maybe it's the color. There's something that draws me into thinking that other people may be confused that the product that they're looking at is mine, but it really isn't. This goes to quality, right? It could be inferior quality. Look, we were talking about Rolex earlier. You can go down the street, you may see a street vendor, and they'll have a watch, but it's called Polex, right? So it's not Rolex. It may look like one, but it isn't. When you pay $5,000 for one and you pay $5 for another, obviously the quality is going to be different. So what you want to do is you really want to prevent people from using your mark. So number one, it could be a quality issue. So you don't want to have people coming to you and saying, I had this really bad wine that was yours when it wasn't. And secondly, like I said, it dilutes your mark. So you would want to send a cease and desist letter out there to get them to stop using your mark. If you're going to license your mark, this is how you can control it. So if you have, say you have bourbon, you have a bourbon product. You're working with the distributor. In your distribution agreement, you may license use of that trademark because they're going out there, they're promoting your product. You may hire some marketers to go out there and brand ambassadors to go promote your product. So when you're doing this, you're licensing people to use your mark, but what you're also doing in your license agreement is you're controlling the manner and method of how that mark is being used. If you have a product that's very wholesome, we're going to step aside from beverage alcohol right now. So if you just have a wholesome product and you don't want it to be associated with anything that's trashy, well, then you would not want your ad to be published in maybe an adult magazine. So the license can control how the trademark is used. So if you don't do that, not only could you have an issue with people about the quality of your product, but again, you could also lose the value of it because you're diluting the mark. So you can have, when I talked about what are one of the strongest marks, fanciful. So if I have a fanciful mark, one of the strongest out there, I made it up, but then I don't police it and everyone starts using it, well, it could become generic. And if you look up there, there are a couple of marks that I'm sure you're very familiar with. Right? You have aspirin. That's an everyday term. People refer to aspirin. Well, at one point, it was actually a trademark. You have another mark, it's a laundromat. People are going to go to the laundromat to do their laundry. Well, now it's an everyday generic term. Dry ice. I didn't know that dry ice was a trademark. I was like, who knew? But it was at one point, and yo-yo. So again, if the marks aren't policed, they can become generic. Okay, so now we get into the process. So the process for an application, like I said, it takes about 9 months to a year. I usually try to manage people's expectations because most people think, oh, I just apply, and then, within a month I'll have a registration, but that's not the case. So the first thing you want to do is you want to conduct a clearance search. So that's something you can do, or your attorney can do, where you're going to look at, you can go to the USPTO database, you conduct a search and see what has been registered federally. You can also go to the state database and see what registrations have been filed in particular states, as well as business names, domain names. You can do an internet search just for the name in general, find out if it applies to a particular brand, category, or business. So this way you're not wasting your time if you are sold that this is going to be your particular brand, because more people find out that their idea, again, was not unique, and then it's really actually best to start over, in my opinion. So once you find a name that you think is workable, that you think could possibly be registered, you file the application with the trademark office. It takes a while for them to actually process it. So it takes about 3 months for a trademark examiner to even be appointed to your application. So that's a long period of time, right? They want to make sure it meets the legal requirements for an application. And then once it's assigned, the trademark examiner usually takes about a month to 2 months to actually respond to you. So if you get an office action from a trademark examiner, that means that there was something in your application that may be problematic. Your mark may be descriptive. You may find out that your mark is confusingly similar to a registered mark or a pending application. If it's a registered mark in the same category that you're looking to register, say I find a Donna's vodka, somebody already has that mark, they've registered it. So, well, guess what? I'm out of luck. If it's called Diana's vodka, I don't know, maybe there's a possibility, but the trademark examiner may say there's a pending application, so they put my application in suspension. So if that happens, obviously this will take a little longer for it to go through if you can get around it. Now, there are arguments that you can make as to why it's not confusingly similar to my mark, but again, it's a process. You need to respond, the trademark examiner will look at it. If they agree with your argument, then it may proceed to opposition, but if not, your application may be suspended until that pending application either registers or they abandon the mark. So, if there are no objections from the trademark examiner, well then you're lucky, because then it actually will get published for opposition. Now, there's the Trademark Official Gazette that's published every week. And what it does is it prints out a copy of all the registrations or trademark applications that were filed. So people have an opportunity, the public in general has the opportunity to review all these new applications to determine if they may be confusingly similar with their marks, and it gives them an opportunity to depose those marks. So when you publish a mark for opposition, you have 30 days to potentially oppose to the mark. If there's no opposition, great, then it will actually proceed to course. If there is an opposition, well, you'll receive a notice from the trademark office telling you that someone may oppose it, or they may file an extension because they want to think about whether or not it's similar to yours, and that they're going to oppose it. So again, this will add time to your application. If I have an intent to use application submitted, and there are no objections from the trademark examiner, well, then it'll proceed after it's published and there are no objections, the trademark examiner will issue a notice of allowance. So this means that your trademark is cleared barring certain circumstances that it'll register. So what do you need to do if you have an application for intent to use? Well, you need to show that you're actually using that mark in commerce before it can be registered. So intent to use is fine for your application, but to actually register, it needs to be in use. So you're going to file a statement of use stating that you're actually using the mark. You're going to tell them when you first started using it, the date, and then you're going to submit a specimen. So a specimen usually consists of, it could be a label for your beer, wine, or spirits, or it could be a picture of the product. So I'm holding up a bottle and I have the label here, and it shows that it's in commerce. And then, barring any outlandish, weird issues that could arise, you will actually get a registration certificate. If you have an in-use application, you save yourself that one step. You're already using the mark in commerce, so you don't have to submit a specimen, so it's just a matter of the application proceeding to registration. Post-registration. So once you get your registration certificate, you do the happy dance, and then what do you want to do? You want to police the marks. You want to make sure that you maintain the integrity of that mark. And what people don't realize is that after you get your registration certificate, there are a couple of things that you need to do. There's some filings. So between the 5th and 6th year after you get your registration, you have to file an affidavit stating that you have been continually using the mark in commerce, and you pay a nominal fee. If for some reason, if there's some excusable reason why you haven't been using it continuously, then you would file that with the office. After that, year 10 of your application, again, file another affidavit that you're using it, another nominal fee, and thereafter, every 10 years, you file the same thing. People are often surprised that they have maintenance requirements after they get their certificate. I was talking to a new client, and he said he had a trademark. So great. I looked it up. I went in the database, pull it up. It's abandoned. He had no idea. So he's like, well, I got a registration. I said, did you file the maintenance documents afterwards? And he said, no, I didn't know there were any. So while it's a good thing to file on your own, I encourage people, if they want to file their own trademarks, definitely you can go and do that. However, there's certain things that may arise after you do that. There could be certain problems. And one thing that I'm going to say for having a lawyer do your application, usually we have a database that we can follow up for the maintenance documents. So again, we'll have a tickler system, follow up with the client, let them know, oh, by the way, you need to file this follow-up maintenance document in such and such time, so you're aware of it, so you don't let your application lapse. Because if you do, you can lose your mark and then start all over again. And in the US, it's filing first. So if I have a mark and it was registered and I totally forgot about filing my maintenance documents, and I find out a year later that it's over and done with, I can have a competitor or someone else file for that same mark and they'll get it because I let it lapse. So it's just important just to remember, you don't want to go through this whole process and find out that you lost it. So, brief recap. I know I've been going on and on about that stuff. Choose a unique mark. That's really your best bet to get a trademark application, go through and register. Conduct a clearance search. Make sure that you are not infringing on somebody else's trademark, that there's not something else out there, even though it's not registered or in the database, it could be out there. So again, just do an internet search to find out. File for your federal registration as soon as possible, even if you're just starting a business, because again, the process takes a while. Once registered, continue to police your marks and then follow up on your maintenance. Just don't make sure that you don't let anything lapse, so this way you are in good shape and this was not all for naught. Thank you very much. If anybody has any questions, I'm happy to discuss afterwards so we can have the next speaker come up. Thank you.